Let us pray. O Lord, our governor, bless the leaders of our nation. May be a people at peace among ourselves and a blessing to others. Lord, keep this nation under your care. To the Prime Minister and members of the Cabinet and all in administrative authority, grant wisdom and grace in the exercise of their duties. Give grace to your servants. To the Speaker, all members of this chamber, and those who make our laws, give courage, wisdom, and foresight to provide for the needs of all our people, and to fulfill our obligations in the community of nations. Give grace to your servants. And finally, teach our people to rely on your strength, to accept their responsibilities to their fellow citizens, that may serve you faithfully in our generation and honor your holy name. Through Jesus Christ, our Lord. Amen. Say the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those that trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen.
This House is in session. Minutes for the meeting held on Monday, 30th September 2024 to be deferred. Honourable Leader of Government Business.
Thank you, Mr. Speaker. I beg to move that the aforesaid minutes be deferred.
Questions that the aforementioned minutes be deferred. All those are members in favor, please say aye. Those against, please say no. We think the ayes have it. The aforementioned minutes are hereby deferred.
Announcements by Your Honour the Speaker. Messages from Her Excellency the President. Petitions, papers.
Honourable Leader of Government Business.
Thank you, Mr. Speaker. I beg to commanded to lay the annual reports and audited financial statements of Hotel and Resorts Limited for the year ended March 31st, 2023. Also commanded to lay the 2023-2030 National Policy for Improving the Lives of Persons with Disabilities, as well as the 2023 report of the National Advisory Committee to guide the establishment of a commission for improving the lives of persons with disabilities. I'm also commanded to lay the ILO Convention 160, Labor Statistics 1985, number 160, and the associated recommendation R170, Labor Statistics 1985, number 170, along with the ILO Convention 149, Nursing Personnel 1977, number 149, and the respective recommendation R157, Nursing Personnel 1977, number 157.
Notices.
Honourable Leader of Government Business.
Beg to give notice of a resolution that the Parliament of Barbados approve the national policy for improving the lives of persons with disabilities.
Private members' notices. Notices of questions. Reports from select committees. First readings of bills.
Honourable Leader of Government Business.
Withdraw first, right? Of the others. Yeah. Mr. Speaker, I beg to withdraw the merchant shipping bill dated the 11th of September 2024 at order number 12 and substitute therewith with the merchant shipping bill dated the 2nd of October 2024.
Questions that the aforementioned bill be withdrawn and substituted. All those are members in favor, please say aye.
Aye.
Those against, please say no. We think the ayes have it. Honourable Leader of Government Business.
Speaker, I beg to move the first reading of the Merchant Shipping Liability and Compensation Bill 2024, as well as the Merchant Shipping Liner Conferences Bill 2024, as well as the Merchant Shipping Multimodal Transport Bill 2024, the Merchant Shipping Maritime Marriage Bill 2024, and the first reading of the Merchant Shipping Bill 2024.
Questions that the aforementioned bills be read a first time. All those honorable members in favor, please say aye.
Aye.
Those against, please say no. We think you guys have it.
Statements by ministers, congratulatory and/or obituary speeches, personal explanations, motions for leave of absence, oral replies to questions, notices of motions for the adjournment of the House on matters of urgent public importance, orders of the day.
Honorable Leader, Government Business.
Mr. Speaker, I beg to move the suspension of Standing Orders 6, 16, 18, 20, 42, subsection 5, 43, and 44 for the remainder of the day's sitting.
Questions that the aforementioned standing orders be suspended for the remainder of the day's sitting. All those honorable members in favor, please say aye. Those against, please say no. We think the ayes have it. The aforementioned standing orders are hereby suspended for the remainder of the day's sitting.
Government business.
Government Business is the order of the day.
Order number 10, sir. In the name of the Honourable Senior Minister, Attorney General, and Minister of Legal Affairs, to move the second reading of the Sexual Offences Amendment Bill 2024.
Honorable Member St. Joseph.
Mr. Speaker, Parliament is today being asked to concur in some amendments that are proposed to the Sexual Offences Act. I distinctly recall that on a number of occasions in this chamber, the Honourable Member for Christchurch South very stridently called for the amendments to the legislation. He didn't give a particular reason as far as I recall, but on those occasions, sir, we sought not to engage in any counter on that matter because we knew that we were making amendments to the legislation and that it was only a matter of time before we could bring them to this chamber. The Sexual Offences Act, Mr. Speaker, was passed in 1992 and came into force. It became law on the 13th of February of that year. You would think, sir, that 1992 was, or could be considered to be relatively recent in the life of Barbados, and that there would not be so much of a departure from the thinking and from the legal principles that would have applied in only a period of 32 years. But the fact is, Mr. Speaker, that our courts in recent times have become very robust and very activist when considering legislation that we have taken for granted for generation after generation after generation. I only need to remind you, Mr. Speaker, of the recent approach of the courts to the matters of the mandatory death penalty. The mandatory death penalty was treated as an obvious thing by Barbadians, by Barbadian jurists, by Barbadian lawyers for all time. But there came a point in time, Mr. Speaker, when jurisprudence and constitutional theory having evolved, it became necessary to address certain matters in the courts and to measure our law against the standard that is called fundamental human rights. And so, Mr. Speaker, the Sexual Offences Act felt to be measured against human rights provisions, against the provisions of our Constitution. In a recent case called Holder McLean Ramirez, that's one person, and others against the Attorney General. The case was filed sometime before, but as you know, we refer to the case by the year in which the decision is given. So we will call it a 2023 case. And in that case, Mr. Speaker, the claimants sought a declaration that the provisions found in Section 9 and Section 12 of the Sexual Offences Act were unconstitutional and asked the court to strike down those two clauses. Section 9, for the record, is a provision which probably has no more than 12 or 13 words. It says this: any person who commits buggery is guilty of an offense and is liable on conviction on indictment to imprisonment for life. Section 9. Section 12 doesn't directly deal with buggery, it deals really with indecent assault. Sorry, it deals with something called serious indecency. And the reason they sought a similar declaration in relation to Section 12 is because the courts have found that serious indecency could be constituted by an act of buggery between consenting adults. And therefore, the claimants in this case, Holder, McLean Ramirez, sought to have both of those sections struck down. It is now public knowledge that the court found that both of those provisions offend the constitutional protections that are afforded to every Barbadian, and therefore were inconsistent and had to be struck down. Mr. Speaker, we are here to deal not with the buggery provisions that has been struck down and therefore cannot constitute a part of our law anymore. We are here really to deal with the challenge that was created when Section 12 was struck down. Section 12 is a provision which says a person who commits an act of serious indecency a person who commits an act of serious indecency on or towards another, or incites another to commit that act with a person or with another person is guilty of an offense. And if committed on or towards a person 16 years of age or more, or if the person incited is of 16 years of age or more, is liable to conviction to imprisonment for a term of 10 years. A person who commits an act of serious indecency with or towards a child under the age of 16, or incites a child under that age to such an act with him or another, is guilty of an offense and is liable on conviction to imprisonment for a term of 15 years. This is where the challenge arose, Mr. Speaker, in the definition of serious indecency. The Act goes on at 12.3 to say, an act of serious indecency is an act, whether natural or unnatural, by a person involving the use of genital organs for the purpose of arousing or gratifying sexual desire. Now, Mr. Speaker, the problem arose because when all of Section 12 was struck down, an important protection of our young boys and girls, individuals under 16, to protect them from acts of sexual predators, also was struck down. No, it didn't mean that a person, an adult who commits an act, a sexual offense against a person under 16, could not be charged, but they would have had to have been charged under a somewhat more lenient provision, which would not have been able to exact the level of penalty that the horror engendered by such a criminal act would evoke in the average member of the public. So it was important, Mr. Speaker, for us to come back to Parliament and make provisions by way of an amendment to the Sexual Offences Act so as to restore the level and degree of protection that the Sexual Offences Act contained. So that is what we are here to do in large measure. To restore to the law the protection that had been afforded to individuals under the age of 16 in relation to sexual offenses committed against them. Obviously, the language, serious indecency, is legally unsatisfactory. So we have to take a different approach. And that, sir, is what brings us to the doors of Parliament. But over and above that, Mr. Speaker, there are a number of other things which it was apparent needed to be clarified, needed to be modified, needed to be dealt with by Parliament so as to remove some of the confusion and issues that find themselves in our Sexual Offences Act at this point in time. So I repeat, Mr. Speaker, we are not here to address the matter of buggery offenses. That is now dead. We are here to deal with the protection of our young boys and girls. Now, Mr. Speaker, the decision in Holder McLean Ramirez against the state is a very interesting one. I will not indulge my fancy by going through the decision. Suffice it to say that it is what has triggered us making the amendment to the Sexual Offences Act and to cover off at the same time a number of things. Now, Mr. Speaker, if you look at the Sexual Offences Act, you would know that the concept of age is something that has caused a fair amount of, perhaps you could even say, confusion in the way in which the law has treated certain things. So, for example, Mr. Speaker, Section 21 of the Sexual Offences Act says, I'll read it for the chamber. A person under the age of 12 years is deemed incapable of committing an offense under this act. 12 years is considered to be our age of criminal responsibility, so there's absolutely no difficulty there. But then the age of 14 gets introduced. In Section 3.3 of the Act as it exists, the age of 14 gets introduced, and it says, notwithstanding Section 21, which I've just read, a person under the age of 14 is deemed incapable of committing the offense of rape. So we begin to start wondering where we're going, because Section 21 says if you're under 12, you can't commit any offense under this act. But then we have Section 3.3, which then says that a person under the age of 14 is incapable of committing not any offense, but committing rape. And then in Section 5, Mr. Speaker, we talk about sexual intercourse where a person has attained the age of 14, but not yet 16. So we go from 12 to 14, and then we go from 14 to 16. And so what we have is more or less uneven treatment of individuals purely by accident of when your date of birth was. That's all. Purely by accident of when your date of birth happens to be, that determines whether you are treated as a younger person, or if you're treated still as a minor, but as a somewhat older person. Now, Mr. Speaker, we know that our Sexual Offences Act does not deal with consensual sex between people or involving a person over the age of 16 years of age. Whatever you may feel about it, a person over 16 years of age is deemed to have reached the age of consent insofar as consensual sex is concerned. Now, Mr. Speaker, I did a quick look of the global statistics or the global state of affairs, and you will see that in some Muslim countries, there's no age stated. They just say that you must be married. In the vast majority of countries, the absolute vast majority of countries, in fact, you could say the superabundance of countries, the age of consent is considered to be 16. In some, it is 15, others 14, others 13, none lower than that. But the vast majority of states provide that the age of consent for the purposes of consensual sex is 16. That was the law as it stood before 1992. It remained the law when the Sexual Offences Act was enacted in 1992. And Mr. Speaker, I am not here today to change that age of sexual consent. Now, the first thing, therefore, is that having got different treatment in the 1992 legislation of a person, depending on what age you are, it became evident that we need to simplify this. Because you explain to a jury, you go to do a trial, a person is 14 or 15, 16 but not over, another person is below 14 but not yet 12. It really causes a tremendous amount of confusion for the court, for the litigants, for the witnesses, for the jury. So the first thing that we've done in this amendment bill, Mr. Speaker, is to try to standardize the arrangements insofar as age is concerned. And therefore, we now introduce in this bill, in a different way that it was dealt with in the 1992 bill, 1992 Act, the definition of minor. So what we're saying, Mr. Speaker, is that we're introducing a definition section which says that minor means a person who is under the age of 16. So we no longer have to worry about whether you're 14 but not 12, whether you are between 14 and 16. We've taken all those things out and accepting that our law provides and has always provided that the age of sexual consent is 16. We're saying anybody under that is to be treated as a minor. Plain and simple. Now, with that in mind, and I'll leapfrog a bit, in the provisions relating to incest, there's a provision where the bill, I think it is, where the Act, Section 18, refers to the term minor in the general sense in which the Interpretation Act would use it. That is a person 18 or under. But bearing in mind, Mr. Speaker, that because the majority of the provisions in relation to minor are people under 16, we've defined those as minor, but now what do you do with the clause dealing with incest? And the simple provision said we've just changed that to 18 years. So let us put ourselves in the frame of mind that when we speak of minor, a minor in this bill, we are not speaking of a person 18 and under, we're speaking of a person 16 and under. This is not an attempt to change the definition section in other parts of the law. So for those people who may not be within immediate hearing, who may find themselves a little bit confused, the law says that when you define a term in an act, it means what it says in that act. It doesn't mean it anyplace else. So we're at liberty to define minor in a special sense in this act without any expectation that the definition of minor for the purposes of the Interpretation Act or for the purpose of any other act would be changed to under 16. So let's just get that clear. Minor, used in the Sexual Offences Act, means a person under 16. It has nothing to do with any other statutory provision. So when we look at this bill, Mr. Speaker, the amendment I would want to point to first is in Clause 3, which provides an amendment to the substantive Section 3. And this clause does a number of things. First of all, in the existing law, it talks about a husband. Mr. Speaker, I believe you now famously took a case to the CCJ on this provision. We've taken out the gender qualification that is found in this act. So we no longer talk about husband, we are proposing that we say spouse. Because given that the offense of rape can be accomplished other than by a man using his penis, it doesn't make sense having a gender slant to the whole issue. For those who want to put it in straightforward terms, you could constitute the act of rape with a pencil, with a bottle, with anything. And therefore, it does not require a male to commit an offense of rape anymore. So we needed to make that adjustment in the law. The CCJ has dealt with it, but it is important for us to take the opportunity to make it clear. And therefore, because rape can take place in many different ways, and those ways are already contemplated by the Act as it stands, it is important that we get rid of the concept of husband and wife and refer simply to spouse. And that is what we've done here. But we've also proposed in this bill to add, in relation to the concept of consent, persons who have mental disorders or physical disabilities. People who have mental disorders or physical disabilities may not be able to convey that consent is not given. Arguably, a person with a significant enough mental incapacity may not be able to give consent in law anyway. But this was not covered off in the existing legislation, and we would have had to rely on common law cases and dealing with actus reus and mens rea to find out if there was any intent. And we've taken the opportunity, Mr. Speaker, to make it clear that the issue of a mental disorder or physical disability is one which can remove the concept of consent. So the bill says, for the purposes of subsection 1, no consent is obtained where the complainant submits or does not resist by reason of mental disorder or physical disability. So where, because of your mental or physical situation, you submit, or where you do not resist for the same reason, that can still constitute an act of rape. I believe that in today's paper there's a sexual offense, a story of a sexual offense involving someone with mental incapacity. This is something I believe, I don't have any statistics, but I think as members of parliament, we are all out in our communities, and we know that this is something that appears to be happening with alarming frequency. In section 3.3, Mr. Speaker, we come back to I've already talked about it, notwithstanding section 21, a minor is deemed incapable of committing the offense of rape, but just to make it clear, that doesn't mean that he can't do something else, or that she can't do something else. A person who is below that age person who is below that age is deemed incapable of committing rape, but you could certainly commit an indecent assault. And in large measure, Mr. Speaker, the reason for that is because a person who is charged with rape and found guilty is liable to life imprisonment. And therefore, the concept of the possibility of the imposition of a sentence of life imprisonment on somebody who is 15, that's something that we couldn't really countenance as a society. For the purposes of this act, a minor is deemed incapable of consenting to sexual intercourse. I think I adverted to this. If you're over 16, you can consent. That is more or less the universal standard. That's not a Bajan thing, that's global. But if you're under 16, you cannot consent. Now, Mr. Speaker, the current state of the law is that if you are under 16, then consent can present a challenge. And I don't want to get too much into the specifics of the provisions and turn this into a lecture. But a person who is between 16 and 14, or let's put it another way, where a person has sexual intercourse with a person between 14 and 16, it is a defense if you believe that person to be over the age of 16. So if you, of course by you I certainly don't mean the speaker, if a person had sexual intercourse with an individual between 14 and 16, and that's where the term statutory rape and so on came into play. But you genuinely believe, if you have reasonable grounds for believing, that's the way to put it. If you have reasonable grounds to believing, perhaps because of how physically mature the person is and so on, then you have a defense. But we're taking that away from you. We're no longer, well, sorry, don't let me say we're not taking it away, but we're saying that we're standardizing how we approach it. So a person who is 16 and under, if you believe that that person on reasonable grounds is over 16, then you have a defense. There's also, Mr. Speaker, significant improvements, or in fact, significant arrangements in relation to minors. And I'm going to do that which I wouldn't ordinarily do and read the provisions to some extent. We've inserted new provisions. I mentioned the one which deals with persons who are under 16. Here's what the law says, or will say. Where a person has sexual intercourse with a minor with the purported consent of that minor, and that minor is under the age of 16, that person is guilty of an offense and is liable to conviction and indictment to imprisonment for life. But we give you the defense where you reasonably believe that person is 16. But recognizing, Mr. Speaker, that there are a lot of things that happen before sexual intercourse, and we begin to pare back some of the layers of conduct. And so, for the first time, our law will say, at 5B, a person commits an offense if the person, for a sexual purpose, touches, either indirectly or directly, any part of the body of a minor, with a part of the person's body or with an object. Now, I hope this doesn't generate unnecessary debate, because the chapeau says if you do it for a sexual purpose. This does not deal with a situation where you pass and you brush somebody in town. This does not deal with a situation where you may touch somebody with your handbag or with a book or a pencil or whatever it is. The chapeau says that you must do it for a sexual purpose. And sexual purpose, we go further and say for the purposes of this section, touch is done for a sexual purpose if a reasonable person would consider that whatever the circumstances or any person's purpose for the touch, it is because the touch is of a sexual nature, or because of its nature and because of the circumstances or the person or any person in relation to it, the touch is sexual. So, a mere accidental touching of a person who is a minor would not cause you to run afoul of this provision. It must have been done expressly for a sexual purpose, and this is now a universal standard as far as the law is concerned. Sexual grooming, Mr. Speaker. I said we tend generally to deal with the actual sexual assault itself. But for the first time, we're introducing mechanisms in the Act for dealing with the precatory things, the planning things, the things that take place before the actual sexual offense. And Mr. Speaker, let us make this clear. This administration has brought to this Parliament a Child Justice Act. This administration has brought also a Child Protection Act. Whatever chattering may go on in social media or in other places, there has been no government in the history of this country that has paid as much attention to the protection of our children than this Barbados Labour Party administration. We understand that a society raising children is a sensitive issue. We understand that the relationship of a child with his parents, with the adults in his household, those are sacred things. And no state should run in to attempt to fill a breach where a family environment is able to cure that breach. But the fact is, Mr. Speaker, that in today's world, we have dysfunctional families, we have dysfunctional family relationships, we even have perverse family relationships, and it is important, Mr. Speaker, for the state to step in the breach and provide mechanisms to protect our young people from predatory and unlawful conduct. Plain and simple. We don't like to talk about it. We have difficult decisions, difficult discussions, I should say. People who are in loco parentis, you know well the Latin term, Mr. Speaker, and then you find that somehow or another, a little touching of a leg, and then it advances beyond that. You have people who say, "Man, meet me in town," and then it advances beyond that. We don't like to talk about these things because they represent a nasty and unpleasant underbelly of a society. Not just the Barbadian society, these things happen all over the world. But Barbadians get a little embarrassed to talk about these things. Mr. Speaker, we can only afford those who need the protection, that protection, if you're prepared to look at it, call it out for what it is, and then put laws in place to address it. So for the first time, Mr. Speaker, we're looking at grooming. There are some unpleasant things, Mr. Speaker, that we don't really want to talk about. But let me share a little nutshell, a little capsule of a matter that came before our courts. I will be deliberately vague, even though the matter is long completed, but I believe it is important that people get a sense of what we mean when we talk about grooming. A matter came before our courts. A man was charged with sexual assault. Mr. Speaker, the victim in this case was a 13-year-old schoolboy. The first encounter took place in the area of the Fairchild Street bus stand. a very kindly, well-dressed, older man approached this 13-year-old boy, paid him a compliment. How tidy he is. How he's much tidier than the other people his age. How he's so polite. And for some reason, that 13-year-old boy appreciated the compliment and thought it was innocent. Another evening, boy back in the area, and the kindly gentleman approached the boy again. More compliments, more flattery. Another day, he walks the boy walks with him downtown, buys a few sweeties or something, and comes back. Then a $5 bill gets passed to the young fella, some pocket change. Before long, that boy was in Queen's Park with that elder gentleman. I'm not going to go any further, Mr. Speaker. But the point is, there was a progression of conduct which caused this young boy to feel at first at ease and comfortable with the older gentleman. And one thing led to the next. And this schoolboy found himself the victim of a sexual assault of a most pernicious nature. Mr. Speaker, grooming is perhaps the best word that we could use to describe it, because it happens in a way that it doesn't happen abruptly. It's not something that happens suddenly. It's something that happens progressively, gradually. And it relies on the inexperience of a child and his or her inability to differentiate whether this conduct is appropriate or not. So that when it transitions into a sexual offense, sometimes the child does not even know how it is to respond to it. So we now have provided, Mr. Speaker, for an offense of grooming. And that offense is created in 5C, and it will say this, Mr. Speaker: a person commits an offense where, having met or communicated with a minor on one earlier occasion or more. So let's do a couple of things here. Communicated with a minor, Mr. Speaker, doesn't just mean you meet them. A nice WhatsApp message maybe, a little phone call, a message sent by another schoolmate, however it is. However you commit, however you do that communication, it can still be grooming. It can still be grooming. So the act is committed where, having met or communicated with a minor on one earlier occasion. Let me stop again. Why one? Somebody would argue, man, no, man, one is too strict. One is too little bit. Oh, how about 4? How about 8? How about don't bother with the law at all? We take so seriously the protection of our minors from predators that we are prepared to say once is too many. But since we can't charge you for a number less than 1, we can have the 1. Plain and simple. We're either serious about it or we're not serious about it. And therefore, just that one time, Mr. Speaker, just that one time could find a person in a difficult, sticky situation with the law. So, again, the provision says a person commits an offense where, having met or communicated with a minor on one earlier occasion or more, intentionally meets the minor. So that's the other element that comes in. intentionally meets the minor or travels with the intention of meeting the minor, whether in Barbados or elsewhere. And so we know we're developing it in layers. And at the time of meeting or travel, the person intends to do anything in respect of the minor, which, if done in Barbados, will be a sexual offense under this act. Then we have an offense. So what we're talking about, Mr. Speaker, is a situation where a person gradually, but by gradually, it just has to happen the one time. And then if you engage in the meeting, then the offense is completed. Mr. Speaker, the penalty for that offense is imprisonment for a term of 20 years. Mr. Speaker, we've also, I think I mentioned the situation in relation to using minor, and then in incest talking about 18 years. So I'm not going to bother to go into that, Mr. Speaker. We also have some additional provisions at 9. Now, at clause 9 of this bill, we now talk about violation of a person suffering from mental disorder or physical disability. I believe there are other people who are going to speak in this chamber, and they may even touch on that particular issue. So I'm not going to say too much. I will point out to you, though, that the law already has a provision dealing with sexual intercourse with medically, what is called mentally subnormal people. But let me tell you why we've changed it, sir. Section 8 of the law says this: where a person under circumstances that do not amount to rape has sexual intercourse with another who is an idiot, an imbecile, or mentally subnormal. Now, Mr. Speaker, there are some things that we perhaps didn't used to be, and I know that's not parliamentary language, but I'll use it here. There's some things that we didn't used to be too worried about. The concept of being politically correct was not one that even in this chamber we always paid due regard to. But for years, in our Immigration Act, and in other pieces of legislation, there was some language that we used to use. We used to talk about illegitimate children, as if a child could be legitimate or illegitimate. In our Immigration Act, they talked about not bringing in imbeciles and lepers and all kinds of things. This Sexual Offences Act says that, bottom line, where a person under circumstances that do not amount to rape has sexual intercourse with another who is an idiot, imbecile, or mentally subnormal person. Mr. Speaker, we've taken the opportunity to purge the Sexual Offences Act from that language, purge that language from our Sexual Offences Act. So it isn't that this provision is new, it is that we are bringing our law in conformity with modern attitudes. I've talked about how we are treating the minors, but we have further provision in relation to minors that I think it is important that we look at. The new section 9A. A person who intentionally causes or incites a minor to engage in sexual activity is guilty of an offense unless that person has reason to believe that the minor is over the age of 18. A person guilty of an offense under this section is liable on conviction, on indictment, to imprisonment for life if the activity caused or incited involved penetration of a minor's anus, vagina, or mouth with a penis, or any other part of a person's body with any object whatsoever. And it goes on. I'm not going to read out all those provisions, Mr. Speaker, but again, we come back to specific statutory provision in relation to minors. And I think that that is something that should be welcomed by the public of Barbados because, as I said, no administration until now has sought to address some of the issues that relate to sexual offenses and minors. But we go on, Mr. Speaker, engaging in sexual activity in the presence of a minor. You know, there are certain people who are so liberal that they would find that this kind of stuff might be exciting. They might even be using it as a mechanism to groom future participants. But we are saying that such conduct is absolutely unlawful, and the bill provides a person is guilty of an offense if the person intentionally engages in sexual activity for the purpose of sexual gratification in the presence of a minor, or if the minor is in a place from which the minor can observe the person, knowing or believing that the minor is aware of the sexual activity, or intending that the minor should be aware that the person is engaging in sexual activity. So it isn't just the accidental viewing, it is that the person must have intended for this to happen. Must have had in mind, let me do it here because I want so-and-so then the past to see. So it isn't, we're not talking about something that is accidental. We're talking about something where for your own sexual gratification, you deliberately have sex in a situation where it can be viewed by a minor, and that is the purpose, that is the intention that you had. Such a person, Mr. Speaker, if it is dealt with on a summary level, that is in the magistrate's court, they can get a fine of $10,000 or imprisonment for a term of 2 years, but if it goes on indictment, a maximum of 10 years imprisonment. Causing a minor to watch a sexual act. A person is guilty of an offense if, for the purpose of obtaining sexual gratification, the person intentionally causes a minor to watch a third person engaged in sexual activity, or to look at an image, photograph, or video, including animation, of any person engaged in sexual activity. So, Mr. Speaker, you don't have to be in the room where it happens. You don't have to be in the room when it happens. If a person, for the purposes of his own or her own sexual gratification, causes a minor to watch a third person engaging in sexual activity, or to look at an image, photograph, or video, including animation, then, Mr. Speaker, that person is guilty of a criminal offense. We go further, sir. A person commits an offense and is liable on conviction on indictment for 10 years if, for the purpose of obtaining sexual gratification, the person intentionally communicates with a minor, and the communication is sexual or intended to encourage the minor to make to that person or another person a communication which is sexual. So in terms of communication with a minor, what we're talking about is that it must be intended to give you sexual gratification, and it must be intended to establish a repartee between the person and the minor. And then finally, in these provisions, Mr. Speaker, taking indecent photographs of a minor. A person commits an offense and is liable on conviction and indictment to imprisonment for 10 years if the person takes or permits to be taken any indecent photograph of a minor, distributes or shows an indecent photograph of a minor, or has in the person's possession indecent photographs of a minor, whether or not with a view to the photographs being distributed or shown by that person or to others. So, taking the photographs is a criminal offense. Distributing an indecent photograph of a minor, criminal offense. Having those photographs in your possession, Mr. Speaker, will also now constitute a criminal offense. And then finally, publishing or consenting to the publishing of any advertisement likely to be understood as conveying that the advertiser distributes or shows indecent photographs of a minor or intends to do so. So, Mr. Speaker, in this 9A to E, these are new provisions in the Act. We didn't have them in the Sexual Offences Act before. We seek now to identify a number of other areas where sexual offenses, where certain conduct should be deemed to be sexual offenses and therefore punishable by law. I'll repeat them. I don't think any right-thinking member of the public could have a difficulty with it. Causing or inciting a minor to engage in sexual activity. Engaging in sexual activity in the presence of a minor. Causing a minor to watch a sexual act. Sexual communication with a minor. Taking indecent photographs of a minor. Mr. Speaker, as I said once more, we have gone into significant detail to ensure that the preparatory acts, the grooming, the early approaches, all of those things, Mr. Speaker, we are making them clear and incontrovertible breaches of our law and visiting those individuals convicted with heavy fines. Two further matters I want to mention, Mr. Speaker. Section 28 of the Sexual Offences Act is one that has caused lawyers, judges, everybody involved tremendous confusion. Mr. Speaker, you know it well. You know it well. Subject to subsection 31, where an accused is charged with an offense under this act, no corroboration is required for a conviction. But the judge shall warn the jury that it may be unsafe to find the accused guilty in the absence of corroboration. There is not a judge, every single judge of the High Court, every single judge who is now on the Court of Appeal, I say it without fear of contradiction, has approached me as AG, both formally and informally, to say, AG, this section needs to be repealed. Because you can't, on the one hand, say no corroboration is needed, but it could be unsafe for you to convict if you don't have corroboration. Well, that don't make sense. Either you need it or you don't need it. So we are repealing this, we're proposing to repeal this provision and put simply that no corroboration is required. It does no harm to the accused. It simplifies the process of a judge who now has to explain to the jury in his summation what this provision is all about. You don't need it, but if you don't have it, you can got a problem. But that is to essentially say to a jury that you need it. So it places everybody in an impossible position. That is not helpful to the law, and it is quite standard that no corroboration is required, and leave it at that. And I'm very happy, therefore, that we have this opportunity to address this particular issue. The final section that I want to mention, Mr. Speaker, is the section dealing with in-camera hearings. Now, the current law provides, Mr. Speaker, as follows. Where on a trial of an indictment of an accused for an offense under this act, the complainant is a minor, the court shall hear the evidence of the minor in camera. Now, this provision is clear. It says the court shall hear the evidence of the minor in camera, nobody else. Only the evidence of the minor is heard in camera. Where the complainant is of full age, the court may, subject to this section, give leave for the evidence of the complainant to be heard in camera. So in certain circumstances, the evidence of the complainant can be heard in camera. And the court would consider, in an application for leave, the likelihood that publicity of such evidence would prejudice the interests of justice, decency, or public morality, and the effect that giving such evidence in open court is likely to have on the complainant's state of mind. Mr. Speaker, this is an area in which you've had arguments back and forth. There have been people who insist that a trial should be had in public, and others insist that it should be held in camera. Mr. Speaker, having looked at the state of the law across the Commonwealth, we are prepared to provide that trials as it says in section 30, on a trial of an accused for an offense under this act, the court shall hear the evidence of the complainant in camera. So the evidence of the complainant, Mr. Speaker, will be heard in camera at all times. But Mr. Speaker, I'm making it clear to you that we are not preventing a public trial. It is one of the hallmarks of our adversarial system of justice that justice must be seen to be done, and part of that requires that hearings should be in public. The matter, Mr. Speaker, of whether or not to have sexual offenders, registries, and so on, and I'll mention that in a minute. One of the considerations to be taken into account in a small society like in Barbados is that these trials are heard in the open. But the fact is that a complainant who says somebody committed a sexual offense against me, of whatever kind, is bound to have a difficulty standing up in a courtroom or potentially standing up in a courtroom full of onlookers and relating for strangers, because it's already bad enough that you don't got to relate it. You don't have to relate it to a judge. You got to relate it to the prosecution lawyers and the defense lawyers. You have to relate it to the jurors. But then you have the potential, and I say potential only because these days people don't go to court and sit in the public gallery in the way in which they used to do many years ago. But it still happens, Mr. Speaker. Sometimes you have celebrity trials and the courtroom is packed. Other times you have a trial that is really good, you like it, interesting law, but then a fella there to watch you pump a set and parade. What we're saying here, Mr. Speaker, is that we are not affecting the public nature of any trial, but all that we're saying is that we want to allow the complainant the dignity and the respect of being able to relate what happened to him or her, whether you're a minor or the adult, in as limited a way as possible. I think that that is a protection that is modern. There's no reason why the public should come in and sit in court and hear some of the things that that individual would have gone through. And then that individual can see them when they leave in court, butt them in at Simpson Motors the next day, see them on the minivan. So this holding we're not holding the trial in camera, we're simply saying that the court shall hear the evidence of the complainant in camera. Now, Mr. Speaker, I mentioned sexual offenses registers just now. And I will just spend a few minutes looking at that and a few other matters in relation to sexual offenses and the course of justice. There have been many calls for us to establish sexual offenders registry legislation. The arguments have been varied. Some have said that it's important for the state to maintain a register of sex offenders. But then they don't really tell you what is to be done with that register. We've begun the work, and it's important, Mr. Speaker, that we understand that changing laws is not about a knee-jerk reaction. Changing laws will require always, even when the public may feel that we have done something in short order, we've done something quickly. All that means is that we did the consideration of the issues in a narrower space of time, but it doesn't mean that we didn't consider it. We've looked globally and we see, Mr. Speaker, that in the United States, the Sexual Offenders Registry is public. So everybody can go and look and see who did what, when, and so on. In fact, only in the US is the Sexual Offenders Registry open to all to inspect. In other countries, Mr. Speaker, the Sexual Offenders Registry is available only to law enforcement or to institutions where children are involved, so that schools could get information from the Sexual Offenders Registry to see if a potential member of staff is guilty of predatory conduct or guilty of sexual offenses generally. Yeah. So that is another way in which sexual offenders registries are used. And yet another way, in some jurisdictions, is purely for law enforcement so as to make investigations of future sexual offenders cases easier. Mr. Speaker, the Cabinet of Barbados has not made a policy decision on whether or not we will establish a sexual offenders registry in Barbados. What we have done is invited an esteemed scholar from the University of the West Indies and a criminologist of tremendous respect across the entire Caribbean to do a study for us, to take all the views into account, and also to do research and make a recommendation to us as to what direction Barbados could consider going in relation to sexual offenders registries. I can tell you that the view amongst Barbadians is divided. Some people believe that in our small society where everybody knows everybody else, that it isn't necessary. They argue that because cases are held in public, you know who is the body who has been charged, that there's really no need for a sexual offenders registry in that way. Others argue that it is true that the name of the person will be published if they're convicted, but who sits down and keeps that information in their head? Which school or primary school, who at the Ministry of Education, you remember, where, oh, you know something, that man get charged with rape, or he was convicted of rape. Nobody remembers that. So it may be important to have a central database that where limited access could be made available in special instances. So the views are divided, Mr. Speaker. As I said, Cabinet has not developed a policy position on it. The matter is being studied. My office has engaged a consultant, a lecturer at the university, to do it for us. I expect that we will have a report he's promised us before the end of December this year, and thereafter I'll be able to go to Cabinet with some proposals. The final thing I want to mention to the court is this, to the chamber is this, Mr. Speaker. The country knows that we have been battling with the backlog of cases in the criminal court. I'll say it again because I think it is worth repeating. Until we came to government, there were only two judges doing criminal work. And as you well know, Mr. Speaker, those judges didn't do criminal work all the time. They would do criminal work for 6 months, sometimes 12 months, and then they leave, go to civil bench to do family or to do whatever else it is. So you had a difficulty building up a corpus of skilled criminal jurists who had the benefit of working in the system all the time and being completely immersed in that area of law. Only two, sir. And at that time, Mr. Speaker, the number of cases was well over 1,000. It has always been the case, Mr. Speaker, that the number of sexual offenses cases has always been an inordinately large percentage. The last figures I got indicated that we had over 400, almost 500 sexual offenses cases awaiting disposal. The number given at a recent symposium with the bar looking at the civil procedure rules, the number given for the number of total cases on indictment is in the region of 1,800. So you can see, sir, that we have a large percentage of sexual offenses cases waiting to be tried. Only in the last week or two, the courts disposed of a sexual offenses matter where the actual offense took place well over a decade before. Now, Mr. Speaker, being in government is not to defend the indefensible. It is not. And I cannot countenance a situation, Mr. Speaker, where somebody gets raped 15 years ago and is now asked to come to court and give evidence of that rape. They've had to, for most unpleasant things, you actually try to purge these things from your mind. But ask somebody who has hopefully come to grips with what has happened and moved on. If possible, you're not asking them to strip away all the healing scab that had built up on this thing over the years to come now and say, when I was 16 years old, this happened. And the body might now be 30. They may now be married with children, or whether or not married, have children. And the system is such that they're now being asked to come forward to give evidence. Mr. Speaker, that is indefensible. Now, Mr. Speaker, I, as Attorney General, this cabinet as the executive, this parliament as the highest court on the land, cannot go in the court system and pick out 500 cases with sexual offenses and say, don't do nothing else, do those. But I can tell you what we have done, Mr. Speaker. When we increased the number of judges on the criminal bench from 2 to 5, it was because we understood that it was an enormous backlog that we had to deal with, and some of these are going to be rape cases. And then we increased it from 5 to 8, again, taking into account the fact that there have been a tremendous amount of sexual offenses cases that have been built up. Mr. Speaker, this chamber, I as AG, we cannot direct the Director of Public Prosecutions. We cannot tell them which case to bring forward. You well know, Mr. Speaker, that one of the challenges at the bar is that the number of high flyers in the criminal legal profession are few, and everybody wants them. So there are some days when a person like you might have multiple cases set before several judges and you can only do one. So there are some challenges in the system. There are. But by putting 8 judges to deal with these matters, by increasing the number of staff, the DPP's office only had 8 prosecutors when we came to government. Mr. Speaker, today they have 20. I want the public to understand what a significant transformation has taken place in the matter of criminal justice reform. Criminal justice reform, and for the stated purpose of making sure that cases go through the system quickly, go through the system with a minimum of friction and waste, that go through the system so soon that people don't have to be scratching the memory 10, 15 years later to remember, was that person wearing a red shirt? It was a red Banlon shirt for those of an older generation. Remember, for St. Lucie and St. Peter would know what Banlon is. Maybe, maybe not. But was the person wearing a red shirt with buttons or a red shirt, a red t-shirt? So we have recognized, Mr. Speaker, when we came to government, it was bad. And we were determined to fix it. Because everything about fixing it is what will make sure that we help to bring down the incidence of crime in our society. Now, Mr. Speaker, sexual offenses is one of those things people don't like to talk about. But the number of sexual offenses cases simply must be brought down in exactly the same way that we are bringing down the number of firearm cases to be tried, the number of murder cases to be tried. And I am satisfied, Mr. Speaker, that this administration is making a dent. I am sorry to all of the individuals, both men and women, whose cases have been languishing in the system for many years. But we are getting there, and we are committed to getting there. Mr. Speaker, I hope that this chamber will see its way to support this legislation. We've looked at the existing Sexual Offences Act. It is not a big act, it only has 30-something sections. And I think that we are making today important interventions in significant areas of the legislation. I think that the clauses of this amendment bill will demonstrate that one of our focal points is the protection of minors. The Sexual Offences Act did not deal with it effectively, and we are now proposing to introduce new offenses. I use the term preparatory, precatory, there are a number of terms you can use, but the things that happen before the ultimate assault takes place. We've tried to put things in place to deal with those issues. I look forward to the support of the chamber, and I believe, Mr. Speaker, that this attempt to modernize our sexual offences legislation will be welcomed by all of the people who have a relevant interest in it. I'm obliged to you. I beg to move that this bill be read a second time.
Honourable, brace yourself.
I'm obliged to you, Mr. Speaker, and welcome back. Your Honor, I'd first like to begin by expressing indebtedness to the learned Attorney General for acknowledging that these amendments are brought here today in response to my protestation that there was a lacuna in the Sexual Offences Act that put children to disadvantage in this country for having lost the protection of that Sexual Offences Act, and for the sake of clarity, that protection was lost for over a period of 2 years. However, I want to express gratitude to the learned Attorney General for bringing the amendment. I suppose one will utter the language of forgiveness, better late than never. Now, I'd also like to acknowledge government's role in crime. We've heard over the last few weeks and months this misguided statement that you cannot blame government for criminal activity. And I think one needs to investigate that statement and explain that statement. That statement, I beg your pardon, for its illogical content. When one speaks on crime, one is not blaming government for every incident of criminal activity. One is saying that government has a responsibility to pursue policy and to do what this Parliament intends to do today, bring legislation to either prevent or control or resolve the issue of crime, so that one lives in a society in which one does not wish to hear these excuses made about government's participation. I repeat, it is government's responsibility to formulate policy and to bring legislation which deals with criminal activity. And that's why this government has brought this legislation today in an attempt to meet that responsibility. So hopefully, those persons within the public domain who seek to make excuses for government's dereliction in its duty to bring legislation with some haste, those who make the excuses for that, hopefully, will now cease to make those excuses and to, as I did, to ask and to urge government to always actively pursue policy and to bring legislation which deals with the control, if not the prevention, of crime. So I thought I would begin by clarifying government's role. Now, I begin also by saying that I am pleased that the amendment resolves the issue as to who is a minor under the legislation. As the learned Attorney General said, the legislation has been, and it is because it is still law, it has been all over the place as to the issue of what is a minor, 14 in some cases, 16 in others. And the amendment today resolves the issue of minorship at the age of 16. Parliament is sovereign. And being sovereign, I believe that laws passed by this Parliament apply equally to all persons, so that if there is activity in Barbados which appears to be legitimate under the law, which brings people under the age of 16 into natural sexual intercourse. I hope the other side understands what I'm saying. My language is subtle at this point. If there is activity that brings persons under the age of 16 into acts of sexual intercourse, since Parliament is sovereign, the government may want to make further inquiry as to the breadth of this amendment today. I say no more on that, but I do say that Parliament is sovereign. I want to ask the permission of the learned Attorney General to correct something he said when he said that Parliament is the highest court in the land. That's not true. The highest court in this land is the Caribbean Court of Justice. And that phraseology about Parliament being the highest court of the land has its origins in English constitutional law. Indeed, there are those who will challenge the very existence, the very concept of English constitutional law. But that was a statement that had application to the British House of Lords, which used to be the highest court in their land, but it was also the highest body of Parliament. And as the learned Attorney General knows, as a West Indian trained lawyer, cases reach the apex of the appellate process when they went to the House of Lords. That is the British Parliament. Except that not every member of that Parliament presided over the case. There was a judicial committee, I believe, of that Parliament, and They were judges, obviously, but they were also members of the House of Lords, so that the highest court was a subset of the British House of Lords. But there were lords of that house all the same, and that is where the nomenclature originates, in that they would say that the British Parliament is the highest court in the land. That has no application within this Westminster system that is Republican only by presidentialist amendment. That is something that the learned Attorney General will be mandated to fix over the next few months to make this country a genuine republic, and so that we can resolve whether we are Westminster or Republican, but we are balancing somewhere between the two. It is a constitutional dilemma that presents to this country, and hopefully the learned Attorney General, with his newfound energy, will fix that situation as to our constitutional status. But I just close on that issue by saying to this country that this Parliament is not the highest court in the land. This state, I say this so often in here, this state finds itself divided between three agencies of the state: the cabinet, and I'm going to say it again, the cabinet, this Parliament, and the judiciary. And by the doctrine of separation of powers, the powers that reside within those three arms of the state must not be concentrated within one individual, and when it becomes concentrated or appearing to be concentrated within one individual, you call that tyranny. And for the avoidance of tyranny, you have the doctrine of separation of powers, so that this Parliament is not a court, and certainly this Parliament is not the highest court in the land. The highest court in the land, I believe the name of the street is Abercrombie Street, where you went, sir, in Port of Spain. You and I went there. That is the highest court in this land, the Caribbean Court of Justice. So for all the people in Barbados, this Parliament has a restrictive role under the Constitution of making law, Section 48 of the Constitution. It is mandated to pass law for the peace, order, and good government of this country. And when that law is tested, it is tested properly only before a court, only before the judiciary, the High Court, the Court of Appeal, and the highest court in the land, the Caribbean Court of Justice. Let that be resolved from today, sir. I don't intend this as any lecture. I just want the people of Barbados to understand the Constitution under which they live. I have something else to say about the amendments that are proposed today. Beg your pardon, sir. I don't complain when legislation reaches me late. It doesn't matter. It is legislation. I've seen it for the first time this morning. I came here expecting a different debate, but I'm going to deal with this. I sit here, and while the Attorney General is speaking, I make my notes. So I don't complain. It came today. It is written in English, and I'm going to deal with the English that's written before me. Now, Your Honor, something very interesting happened here this morning. And I'm addressing the public as much as I'm addressing you. In fact, I'm addressing the public through you, sir. But of course, primarily, I'm addressing you. Now, to thunderous applause this morning, as thunderous as the applause could have been with these depleted numbers, let me pause and say that it becomes a concern of mine, and it must become a concern of the people of this country. And you will tell me, sir, whether I'm speaking in breach of the standing orders of this Parliament. But it must become a concern that from week to week, you cannot preside over a parliament of 29 members. And this is important legislation. And if I'm going to breach the rules by counting the persons in here this morning, I am not going to breach the rules. I am not going to breach those rules. But this is an important legislation. This is legislation that ought to invite fullest participation, fullest membership participation possible. Something happened here this morning, and I'm indebted to the learned Attorney General for the exposition that he gave on this amendment. To thunderous applause. Well, the few hit the desk hard. The learned Attorney General said that this administration has brought a Child Justice Act, a Child Protection Act, and there was a certain self-congratulation and congratulation from his colleagues. And yes, a few weeks ago, those pieces of legislation came before this chamber. The Child Protection Act, to which the learned Attorney General referred, had somewhat of a difficult life because there were protestations within the public domain as to whether it had any validity, and that is to say, social validity, whether it was accepted by the public. In spite of that boast, and I've heard it, I want to say to the public that although this government has brought a Child Justice Act and a Child Protection Act, this same government continues to give financial support and sponsorship to a morally decadent culture. That's what I say. And that is what the people of Barbados understand. And I repeat, without fear, and I caution this government to curb its propensity to inculcate within the culture of this country, within the social mores, events that contribute to moral decadence. And I'm not speaking of adults now. I'm speaking of the children, the innocent children of this country, who continue to be exposed to moral decadence. It used to be in the dark nightclubs. That's where it used to be restricted, away from children. That's where it used to be. But I am pleading with this government to do what is in its power to genuinely protect the children of this country from events. And I think everyone knows what I'm talking about. From events that adversely influence a child's concept of what is right and what is wrong. It comes in many forms. It comes in many forms. And if the government thinks that I am accusing them alone, we must never be afraid to tell the truth. Public transport. What you hear on public transport is no protection of children. And nobody is going to blame the government for what the children hear on public transport. But the government has a role. If our 5 and 6 years old and 7-year-old children are exposed to lewdness and decadence on public transport, do something about it. Do something about it. The state controls the routes on which they travel. The state also has it within its power to control the emission of sounds, music. You go to other countries, you don't hear music on public transport. Public transport is intended to take you from your point of origin to your destination. It is not a zone of entertainment. And if it becomes a zone of entertainment in which the minds of children become corrupted, the government has a role to play. I repeat, one does not blame the government for the music on public transport. One says that the government is derelict in its duty if it fails. Why is there this inertia? Why can't the exposure of our children to moral decadence, why can't that be controlled? Why is there this inertia? Why is there this fear? While at the same time we come in here and boast about legislation, which sometimes is not acknowledged in the public domain. So I want to say, Your Honor, that it seems that there's a kind of a dissonance between government's legislative activity and government's social and cultural investment in the youth of this country. I do not boast. And if I threaten immodesty now, I beg your pardon. But they give us some money every month. As parliamentarians, the public needs to know this. If some of us are here not spending it on the people, well, that's a matter for them. But I accumulate mine. And I'm not going to say what I do with it, except to say that every year that I have been a parliamentarian, I have spent much money. Not going to give the amount, much money. In a summer camp program for the little children in my constituency. And not only are they from my constituency, Your Honor, they come from Christchurch East, they come from Christchurch West Central, they come from Christchurch East, I can talk about it. They come from Christchurch East Central, and I suspect Christchurch West is a little too far down the road. I wouldn't mind bringing your children up here, up to my constituency. I wouldn't mind, but it's a little far. So they come from all over Christchurch. And those of us who know the New Testament suffer the little children. Suffer the little children to come on to, not me, but to righteousness. Mothers of Salem, Honourable Member of St. Thomas knows this. She and I went to Sunday school every Sunday in our childhood. When mothers of Salem, their children brought to Jesus, yes, the stern disciples turned them back and bid them to return. But every summer, I bring the little children of my constituency to my community activity center as part of my obligation to the children in this country, and they don't come there and listen to what they may hear on the public service vehicles. They come there as part of their wider education in social studies, and I make no apology for this, religious studies. And that is where, as my grandmother used to describe it, the few coppers, that is one of the destinations of the few coppers that they give me every month to service the constituency. And we take them to Harrison's Cave. And we take them to other places of interest in Barbados. I urge all of my esteemed colleagues in here to find themselves spending that money on the children of this country. I look to my left and I see the Honourable Member for St. Michael East. He knows what I'm talking about. But when he gets up to speak, he has his own trumpet and he can blow it. But I say all of that to say that if with that small sum, I can try to do so much. What can this government do apart from passing legislation and increasing the number of judges? It is not enough. It is not enough. And this government is failing in its public duty to save the children of this country. The Child Justice Act and the Child Protection Act may well mean a lot. It is not enough. Let the parliamentarians of this place begin to immerse themselves with depth and seriousness in the social problems that are afflicting the lives of our children. I will leave that and come back immediately to the legislation. Something very strange happened here this morning. Very strange. I think I'm hearing another voice. If somebody is rising on a point of order, I will give way, sir. If someone is not, I think you will prefer to hear my sole voice. Now, I want to come, and I want to come to the legislation, and the Attorney General, the learned Attorney General, I think he was academic, and I'm grateful for that academic pursuit. And I'm looking for the note on which I made the paper, the paper on which I made the note, I beg your pardon. The Republic of Barbados, yes. Section 3. Section 3, and come let us reason together. Section 3 of the Sexual Offences Act, that is the law, even while I speak, and the learned Attorney General brought the country's attention to this. Section 3, subsection 5. It reads, and this is the definition of rape, the statutory definition of rape, which, as you know, Your Honor, accords much with the common law definition, except that it widens it. You're a lawyer, and a good one, and you know precisely what I'm saying. And they don't let you speak in here, but you, I suspect, will agree with me. It's ironic, a speaker does not speak. Now, it says, a husband who commits the offense of rape is liable on conviction, on indictment, to imprisonment for life. For the purposes of this section, rape includes the introduction to any extent in circumstances where the introduction of the penis of a person into the vagina of another would be rape. That's, we call that the creation of the offense of rape by a husband on a wife. And that was quite revolutionary when it was passed, because you know the Judeo-Christian injunction that a wife must submit to the husband.
The case of R versus Edwards,
R
1991.
versus Edwards, indeed, sir.
1991.
What year was that?
1991.
1991. So that there was this previous thing that a wife had to give in. You had to submit. And so many brides went down that aisle to the priest and returned to the reception, discovering that they did not have a choice. That when the husband said he was ready, she had no choice but to be ready. And in its wisdom, a parliament intervened in defense of the rights of women. It was an intervention which was in keeping with good justice. And it became the law that a husband who disrespected the moral and bodily rights of his wife could be found guilty of rape. And from the date of this legislation to the present, even while I speak, a husband may commit the offense of rape on his wife. The learned Attorney General tells us today that there's now this amendment. You must forgive me, sir. I made these notes just a few minutes ago. Yes. And just forgive me, sir. I'm turning the pages. So that the previous legislation contemplated rape within marriage between a man and a woman. Between a man and a woman. It was heterosexual. This is what we have today. The language of rape under the law that exists now until this government decides to change it sometime this afternoon was that the offense of rape is committed between a man and a woman. This Parliament, this government, through the voice of this Attorney General, now makes the language gender neutral. And it no longer speaks of a man against a woman, but it speaks of a spouse against a spouse. It is gender neutral. And presumably that may now relate or refer to the wife committing the offense against the husband, spouse and spouse, because it becomes gender neutral. And I'm not sure the learned Attorney General said this. He may well have done so, but he will correct me in reply. It can be committed with the use of implements, obviously, woman against man, but let us not travel into the gory details. It is gender neutral, and therefore the offense may now be committed by the woman against the man. But it says spouse against spouse. Now, we have to be very careful how we pass law in this country. We have to be very careful about what we convey to the public by the passage of law. Maybe it is taking us unwittingly into the zone of homosexual unions. We have to be very careful. We have to be very careful. There's something called, I think they call it colloquially, same-sex legislation. This is not same-sex legislation. Marriage in Barbados is still monogamous. Still monogamous, sir. I paused because I knew. It is still monogamous. The case, Hyde and Hyde. You know the case, sir. And it is still heterosexual. Now, whatever our philosophical and political views, the definition of marriage in the case Hyde and Hyde still describes it as monogamous and heterosexual between one man and one woman, one man and one wife. Trying to remember the name of the judge. Was it Butland? I think that was his name. The voluntary union for life between one man and one woman. So that it was monogamous, heterosexual, voluntary, and permanent. That was his definition of marriage. Obviously, the right to divorce means that it is no longer permanent. And so the other elements remain. You cannot be forced to marry. And if you do, if you force a man to marry, that marriage becomes annulled. So it still is voluntary. The element of voluntariness remains. The element of monogamy remains, because you cannot marry two women at the same time. And it is still heterosexual. That's the law of Barbados. That is the law. So that if this legislation today seems to be, and I say seems to be, the learned Attorney General is clever enough in his reply to get up and clarify for this country whether the gender-neutral language of spouse and spouse may possibly broaden and extend itself to include a man and a man, or a woman and a woman. Because in some countries, that is why the legislation has become gender neutral, to provide for cases of homosexual union. So he will, in his reply, allay the fears, any possible fears, that the neutralization of the language is meant only to criminalize the woman for acts against the man, and that it is not also intended, being gender neutral, spouse and spouse, to refer to two men or to two women. That will be the responsibility of the learned Attorney General when he replies. That is not my duty. My duty is to provide constructive opposition. And in providing, I knew on that you would pipe up. I knew on that issue you would pipe. Relax yourself, son. Relax yourself. If you wish to say something, you will get a chance to speak. But I knew, I sensed that you would, that your spirit would suffer some disturbance. So that, Your Honor, where the language becomes gender neutral, tell the people of this country that the neutrality of the language does not extend to same-sex unions. That is my point. I repeat, in neutralizing the language, tell the people of this country that neutrality of the language does not extend to same-sex unions. And that is not an expression of homophobia. That is to give absolute, that meets the duty of this Parliament to give absolute clarity to the people of this country that this legislation, this amendment, when it says spouse and spouse, when it disguises, when it conceals, when it obscures the sex of the parties, that it does not extend to same-sex unions. Whether they pass the legislation or not, if that time comes, we will obviously debate it. But the government must not appear to be introducing the legislation. The government must not appear to be introducing the legislation incrementally. Because in neutralizing the language, the legislation also could have said, by a male spouse against a female spouse, or by a female spouse against a male spouse. And that would have preserved, beyond the shadow of a doubt, the heterosexuality of the union. But we all make mistakes. We are human. And the Attorney General, the learned Attorney General, may have overlooked that. He may have overlooked that. And there's no reason to feel squeamish on that. We are legislators, we are parliamentarians. We belong to a sovereign parliament. We have the right to pass law, but we also have a duty to clarify the nature of that law. And I say again that this learned Attorney General, this Parliament, has a duty to this country to say whether this section pertaining to spousal rape is restricted to heterosexual unions or whether it extends itself to unions that are homosexual. And I'm saying, sir, that the draftsman could have stated, could have sent the Attorney General here on his mission to clarify, I repeat, and to say that the offense may be committed by a male spouse on a female spouse or by a female spouse on a male spouse. And that leaves it clear that the union is heterosexual and that it may be committed by either party to that heterosexual union. But that where you exclude the words male and female, you may be treading on ground that ought to be introduced to the public explicitly, by explicit language of any legislation, whether it is this legislation or legislation dedicated to the issue of the definition of unions, of marital unions. I ask, therefore, the learned Attorney General, I ask this government to take a second look at the legislation and bring clarity to the issue of the types of unions that this Parliament recognizes. Now, I applaud the learned Attorney General for section the proposed amendments and for establishing categories of offenses. And I will read the rubric: sexual offense, sexual intercourse with a minor, sexual touching of a minor, meeting a minor after sexual grooming. And then it goes on to create other offenses involving entrapping children into sexual situations, photographs, and taking pictures of them. That is certainly an initiative that deserves some commendation. It is in keeping with situations in which people are using technology to further sexual exploitation of children. And I congratulate the Attorney General for having the foresight, for being visionary enough to embrace the criminality of those sinful relationships in which predators entrap children by use of technology. Innocent children. We must always see our children as innocent. And we must always be slow to condemn children. They don't have the same legal responsibility that we do, and that's why the learned Attorney General would have sought to standardize this question as to who is a minor. He places it at 16. It used to be at 14, 16 for others. In the old days, it would have gone as high as 18. And in even older days, it may have gone as high as 21. Of course, that was a part of the Middle British inheritance, because while they were calling 21 the age of majority, we had people around here leaving school at the age of 14, finding jobs, and by the time they reached 16 and 18, they were adults. except that the law of England, which we inherited, was referring to them as minors. So I applaud the learned Attorney General for reaching some kind of cultural settlement in which the age of 16, in his view, and in the view of the government, becomes the age of acceptable moral and criminal responsibility, the cutoff age. You, sir, were described by the learned Attorney General as one of the eminent criminal lawyers in this country. And no one in this chamber, nor in Barbados, will challenge that. And I looked in your direction on this question of corroboration. That corroboration is now abolished. I think Section 28, yes, Section 19 of the amendment. And it says, where an accused is charged with an offense under this act, no corroboration is required. And there's the public asking the question, what is this thing called corroboration? And corroboration is a matter of evidence, Your Honor. You know this, so I speak through you to the public. And we are on the subject of rape and sexual offenses, that when a person is charged with a sexual offense, let us say rape, and his accuser makes the allegation, the law has always considered that the allegation by itself is not enough. And the law has required this thing called corroboration. In other words, evidence which supports the allegation.
Independent evidence.
Independent evidence. You're such a good lawyer, sir. Independent evidence. Evidence independent of what his accuser says. The complainant. Independent evidence. When we used to be at the assizes in the early days, in their summations, the judges used to say to the jury that, I don't know if they do it still, that you see, jury, this offense of rape is a difficult one because it is easy to allege. It is very easy to allege. But sometimes proof is difficult. And they used to say that because I don't know if they still do, but they used to say that in recognition of the peculiar nature of the offense of rape, that a lady can walk into a police station now and say that a man raped her. And the police service is under a duty to accept her report, to accept her allegation, to investigate it, and if the investigation reaches a point in which she insists that it happened, they're going to arrest the man because the lady said he raped her. Of course, they will investigate where he was at the time and so on and so forth. Supposing he gave her a lift in his car. Foolish man that he is. You don't walk out picking up young ladies. If they're driving 500 yards down the road, let them walk. Don't put any young woman in your car. It is unwise. And so, it is easy for her to make the allegation. But the law, as we knew it, required corroboration, independent testimony. You know, Your Honor, that corroboration may even be medical evidence. Evidence of a struggle. Evidence of violence. Independent testimony from someone who saw the two of them together, who saw them enter a house and emerge from the house. All of that is corroborative evidence. All of that is evidence, independent evidence, evidence independent of the lady's report that the offense took place. I don't come here today to quarrel with the learned Attorney General. You're the criminal lawyer.
I remember you used to do criminal work also. So don't say I'm a criminal. Don't you do criminal work? I remember.
I do, sir.
Well,
I do, sir. But I was trying not to make myself the focus. And I wondered today about the tremors that have gone through your fraternity when they hear, when the lawyers at the bar, the criminal bar now hear, that this legislation will abolish corroboration. And what the learned Attorney General said, that the judges do say, it does not defy logic. I want to say that to the learned Attorney General. It does not defy logic if a judge says to a jury that no corroboration is required for a conviction, but the judge shall warn the jury that it may be unsafe to find the accused guilty in the absence of corroboration. The learned Attorney General understandably had some difficulty with that. But you and I at the criminal bar, we don't have a difficulty with that because you see, sir, this fundamental right to a fair trial and to be considered innocent unless evidence beyond reasonable doubt. That must be the nature and quality of any evidence that convicts a man. It must be of a standard that makes the jury feel certain, sure, that the offense was committed. And that is why you need corroboration in a rape case. Or that is why it was desirable, not need, it was desirable to have corroboration. And that under the law that existed then and still exists today, that is why the judge would have said to the jury that although you don't need corroboration, yet it is unsafe to convict a man without it. That doesn't defy logic. Doesn't defy logic at all. For absolute clarity, the state of the law is that you do not need evidence. In other words, in legal theory, a man may be convicted of rape on the woman's evidence alone in legal theory. But good prosecutors know, and good police officers know, and good doctors know, and good witnesses know that it is unsafe for a jury to convict a man on the lady's evidence alone. And that is why the principle of corroboration came to life. That although you don't need it, the learned judge says to the jury, you don't need it. You can hear her and believe her if you wish. But I want to tell you, jury, that it is unsafe, it is possibly a breach of his rights to fair consideration of the evidence, to convict that man unless you have independent evidence. And independent meaning evidence from some other person, whether it is a medical doctor, eyewitness to the aftermath. And I say to the learned Attorney General, the abolition of that principle does cause me some discomfort. Since a trial, there must be some, what I would describe as evidential equality during the course of a trial. Everybody must have a fair chance. The victim has her rights, and she must be given a fair chance to express herself evidentially. In other words, to give her testimony. And she must be given the right and the opportunity not only to be heard, but to be believed. But so also must the accused. And in the discharge and the recognition of that right, if an accused man must sit in a trial for how many ever days, 2, 3, 4, 5 days of a rape trial, and here the complainant alone, the lady alone, and not have any independent testimony which corroborates, and if you don't like the word corroborates, which confirms the allegation, which proves the allegation, the trial has not been fair to him. So that it is not a case of being unfair to a woman. You must be unfair to neither. And indeed, the corollary of that is that you must be fair to the woman, the victim. And you must be fair to the man. And if the resolution of the matter renders the trial unfair, evidentially unfair, it has not been a fair trial. And it is a matter of some regret that I meet the abolition of the requirement for corroboration. It is a matter of some considerable regret. Permit me, Your Honor, to read what is the proposed amendment. And it is very short. But it does severe injury to the fairness of trial. It does severe injury to the fairness of trial. These are the words, Your Honor. I wonder if you will leave here and start to draft your constitutional motion as to fairness of trial. The learned Attorney General disclosed to this country that you have some other matter somewhere and you are challenging constitutionality. You have that right, sir.
Honourable Member, I don't think the Attorney General said that.
You don't?
He did not say that.
Oh, I see. Well, you are known, you have challenged the constitutionality of legislation before. So that if the Attorney General had said that, he would be correct. But you don't wish me to personalize it. But when I saw you making notes, I thought you were perhaps making notes as to the constitutionality of this amendment so proposed. Let us read it, Your Honor. Subject to Section 31, these are now the operative words. And please, Attorney General, don't see this as, this is academic. Come, let us reason together. Right. Come, let us reason together. Where an accused is charged with an offense under this act, no corroboration is required. I don't know how that greets you. I don't know how that impacts against your sensibilities, your constitutional sensibilities. But it seems to trespass against Section 18 of the Constitution, which guarantees the fairness of trial, that an accused enjoys the right to a fair trial. And that proposed amendment, sir, causes me to pause and to ask whether it is a dangerous amendment, whether it is violating fundamental constitutional rights to be tried fairly. That you're saying to an accused, whoever is the person alleging that he can be convicted without independent evidence in support of the allegation. We often say that fair trial is not an exercise in belief. You can believe anything you want. Fair trial is an exercise in proof. That is what it is. So that we often select the juries and exclude some people. I know lawyers that do it. I'm not going to identify them now, sir. That they look at some of the jurors and say, boy, you ain't coming up here. You look like one of those people for whom the state, formerly the crown, is never wrong. And as soon as the name is called and you look back into the jury pool and they stand up, Mr. Defense Counsel says, no, challenge. And somehow they manage to get a jury that they believe will give fair consideration to the trial. A jury who will examine the evidence, all of the evidence. And I say to you, sir, that this proposed amendment curtails the evidence required to make a trial fair. Again, this is not constituting itself as carping criticism of all that the government is doing. Just a caution to the government that when you are amending legislation, give some due regard to the rights of all parties, including the alleged victim, and certainly not excluding the accused. I cannot say enough that this is a dangerous proposal. This is a dangerous amendment. And I would appeal to the government to reconsider it. It may not be taking this legislation into zones of constitutional safety. I really do ask the government to look at it a second and a third time. I don't know if the government consulted the bar. The bar seems to wish to be consulted on everything these days. I hope the government will consult the bar as to this one, and whatever are the virtues in this legislation, this certainly is not a constitutional virtue. That constitutional virtue, or that legal virtue, which, as I said last time, is not always written. Justice is that unwritten virtue that must find itself attending to the letter of the law. And there's something unjust about placing a man on trial. Placing a man on trial and lowering the standard of proof to a point where a conviction can be arrived at without corroborative evidence. So that not only does this amendment trespass potentially against the letter of the Constitution, but, Your Honor, it seems to disturb even, that common law position that the standard of proof must be high. It lowers that standard of proof. And as I said earlier, and I repeat, a man cannot be convicted unless the evidence reaches a standard that is one beyond reasonable doubt, that leaves the jury certain, sure, that the offense was committed. So that this proposed amendment today disturbs the Constitution, disturbs the constitutional mandate for fair trial, and reduces the common law requirement that evidence in a criminal trial must reach a standard of proof beyond reasonable doubt. In other words, you can now have a rape case of minimal evidence. Minimal evidence. The lady comes in and she says, John Brown violated me, violated her. And by this amendment, a jury can convict. And I say to you, sir, that is not satisfactory. So that when the Attorney General counted the words in this amendment, or I don't know, I heard him count 10 words. It may have been this. This is very short. This is a 2-line amendment. But it is more than 2 lines in its dangerous portent and in its dangerous content against fair trial in this country. Again, I ask the government to take a second and a third look and to consult not only with the Law Reform Commission, but to consult with the bar, and certainly consult with the bar that is dealing with these matters on a daily basis. This is a dangerous, very, very dangerous amendment. But if there is any good news, it is that the government has done what we called upon them to do some long time ago. And whereas I will now confess that I thought the government was coming today only to attain to sections 9 and 12, the learned Attorney General, with my congratulation, has extended his efforts beyond sections 9 and 12 and has created new categories of offenses against children. And I was checking, he did say that, the learned Attorney General did say that the absence of section 12, I think it is, did not mean that children were not protected against predators. And I quote him, except that the prosecution could pursue another section, and that section was unsatisfactory because it was more lenient. So I checked the legislation, and I congratulate him for retaining a penalty that is severe. I think it is 15 years. 15 years in relation to a child. Of course, where there's congratulation, there sometimes is criticism. And I've always been curious, sir, as to why sentences are more severe when men commit this heinous offense against adults, and less severe when they commit this heinous offense against children. That is something that I am still grappling to understand it. Are children of lesser humanity? Do they suffer less? Certainly they can't suffer less in a situation of sexual assault, heinous sexual assault. But why, in any event, is a comparison to be made in relation to the suffering of adults and the suffering of children? I think that if a man or a woman sexually assaults a child, he or she should be treated with the same severity as he or she is treated in relation to an adult. And I ask this Parliament to correct that. Are we really serious about protecting our children? Or are we diminishing the suffering of our children through a sentencing tariff that tells a man or a woman, an offending man or a woman, that if you assault sexually a child, you are exposed to a shorter sentence than if you assault an adult. I believe somewhere in the act, you can get life imprisonment for sexual assault in relation to a child. No reasonable adult living in this country will accept a situation in which the penalty for assault on a child is set at a lower tariff of a maximum of 15 years. I don't understand that. Perhaps there's some sociological or psychological justification. I don't claim to know everything, I'm not omniscient, but it appeals to me as, it strikes me as being wrong. And I would hope that we elevate the rights of our children to some equality with adults, and I repeat, in terms of the suffering of humanity. That if you assault a child and you assault an adult, that person, that offender, must be condemned with equal force in relation to children as he would be in relation to adults. I made one other note, sir. I will seek to address you on that. Yes. I will wrap up, sir, by asking the government to renew its efforts genuinely in relation to the protection of children. I said it in opening, and I think it is appropriate that I should close on this, that legislative intervention is not exhaustive of the intervention that needs to be made in relation to the protection of children. We bring them into this world, and it is our duty to protect them. We must protect them in this parliament by legislation, and we must protect them in the wider public domain by our behavior towards them. And I say to the cynics that although government does not walk around out there in active wrongdoing against children, it still remains government's responsibility and duty to invest in and to sponsor and to participate in cultural practices in relation to children that always will secure the protection of those children. And the point is, Your Honor, that I can leave this parliament now and observe practices that remain inimical to the development, the proper development, and the protection of children. I mentioned the public transport before. And to that I could add zones of social activity by adults from which children are no longer insulated. You know what I mean, sir. Certain types of entertainment. We have to be courageous, even at the risk that what we say makes us unpopular. Except that one day I hope that we will consider that we're here to pursue principle and not popularity. Not popularity. And that if a lot of our social activities sponsored, and I'm going to call the name, if a lot of our social activities sponsored by government agencies, to wit, the National Cultural Foundation, exposes our children to immoral social behavior, then they are breaching our responsibility to the children of this country as a state agency. And I urge this government, I urge the schools of this country to take NIFCA far more seriously than our children have been encouraged to take the other forms of entertainment which do them no good. But it is so ironic, and I've said this here before and I'm going to say it again. For those who tired of me hearing it, I'm sorry. That ironically enough, it was the same National Cultural Foundation which normally promotes a wholesome National Independence Festival of the Creative Arts. There is nothing on the calendar of the schools of this country that is more wholesome than NIFCA since its creation in the early 1970s. The school children of this country have not found a more wholesome social, cultural, and artistic activity than that National Independence Festival of the Creative Arts. And how ironic. It must have been, and I repeat, when that same National Cultural Foundation, through the agency of one of its spokespersons, deemed that the right of a group to express itself religiously and conscientiously in accordance with the Constitution of this country, when that agent deemed that a production, an artistic production, was unwelcome. That is as mildly as I can say it. So you can come in here and boast about all the legislation you've passed. All the legislation you've passed. I hear your voice, but I want to see your hands. And it is a dreadful hand that prevented little children, little artists in this country from expressing themselves artistically. That should never happen again. And in vindication of their protests, I can say this in here, in vindication of the protests of those children, we recently heard something of a retraction from the arbiter or mediator. I think he's called an arbiter or an arbitrator. Arbiter. The arbiter recently retracted from his position. How have they resolved it? Will they allow these children and other children the freedom of expressing themselves wholesomely? I always refer to Niemöller. They came for the trade unionists. No one spoke for them. They came for the socialists. No one spoke for them. They came for the Jews. No one spoke for them. They came for all categories of person. And no one spoke for them. And when they came, and certainly the protagonists in the poem, when they came for him, there was no one left to speak for him. And today, we must be that continuing voice in defense of the rights of people, and certainly this parliament must be that continuing voice in defense of the rights of children. And again, I offer commendation to the Attorney General of this country for doing as best he could. But as the song says, his best just was not good enough. There are still portions of this legislation, there are portions of these amendments which leave rights threatened. Your Honor, I have referred to the right of an accused to have corroborative evidence at his trial, I have referred to the question of a possible trespass against the definition of marriage in relation to this legislation. And the learned Attorney General, if he wishes to, will answer that second allegation, if he wishes to. And if, perchance, the learned Attorney General intends that these amendments shall be his swan song, his legacy, his legislative legacy to this Parliament, well, then so be it. But, Your Honor, in closing, I will say that these amendments contain grievous deficiencies. And while the learned Attorney General attempts to solve a problem, and perhaps he has solved it in certain aspects, he now opens up this legislation to constitutional doubt and to injurious treatment of time-honored common law principles as to the nature and quality of evidence which is required to convict an accused person. Your Honor, those are my submissions, and I'm obliged to you. Thank you, sir.
Honourable for Christchurch East.
Mr. Speaker, sir, I raise, as has become my wont, coming immediately behind the Leader of the Opposition, in many respects, sir, to clean up any misinformation that might have been given, any misinterpretation of the proposed legislation, any misinterpretation of existing legislation, and yes, it does put me in a spot, sir, because I'm never now really free to develop my own perspective on everything, having been tasked with addressing and correcting the utterances uninformed at best. I don't even want to say malicious at worst, but entirely uninformed. Sir, I will start, for clarity, because it was the most recent thing that was said, to clarify the position on corroboration. Let me start by the exact last statement that the Honourable Leader of the Opposition made. He said that the Honourable Attorney General opens the legislation to constitutional doubt by removing the element of corroboration. Right before that, sir, he said, as he was speaking about what he referred to as his swan song, he wanted us to take away these two particular points, the first of which was, I have referred to the right of the accused to have corroborative evidence at his trial and enshrine common law right. So I don't know where the Honourable Leader of the Opposition practices law, or exactly how does he prepare himself for his trials. I don't know how he prepared himself to come in here, and I don't know whether he actually...
Honourable Member, you got to speak. Honourable Member for Christchurch South. Honourable Member, that type of behavior is not permitted in these chambers as long as I am the presiding officer. They are not permissible under my watch.
It is interesting that he who begs for protection is the first one to throw the knife. He doesn't even try to get close enough, sir, to actually put the knife in my back, but he often tries to throw it across the well of this house at me. I continue, sir, because I am going to justify every single thing that I'm saying. Sir, to put him out of his misery, let's just go straight, sir.
Honourable Member for Christchurch, so please, I have just returned to this chamber. Things that you might have done in my absence cannot and will not be tolerated in my presence. But if you cannot act with civility, I will soon ask for you to be removed from this honorable chamber. I believe that you know better. Honorable member, I know that you know better. Honorable member, I know that you know better. I know that for a fact. You know the rules of this house. You know the standard orders of this house. If you do not wish to abide by them, I will then ask you not to enter this chamber if you do not intend to abide by the rules of this house. You know them. You are a mature person. You have been in this chamber since 2018. I expect better behavior from you, a seasoned, mature member of this parliament. Yeah, but honorable member Christ, so you cannot ask the honorable member Christ. But no, but you have not said that. You cannot ask the honorable member to say for Christ is to respond to you. Any protestation that you might have must come through this chair. Must have to come through this chair. And as I said before, you know the standing orders of this honorable chamber. And all I will say to you, abide by them before you are taken away from this chamber. That is all I will say to you. If you do not wish to abide by the standing orders, then don't enter this chamber. You know them. You know them. If you do not wish to abide by them, then do not enter the chamber. It is as simple as that.
With respect, Mr. Speaker, the Honourable Leader is misleading the House. I have said over and over, the Honourable Leader of the Opposition, when I refer to him the second time in the same sentence, I use him or he, which is his legitimate pronoun. If he wishes me to use another pronoun, then please let me know.
Honourable member, continue. Please continue. Honourable member, continue, please.
Sir, for the avoidance of all doubt, for the next 5 to 10 minutes until I indicate, sir, that I am moving off of the topic of the Honourable Leader of the Opposition, he can assume with the greatest of respect that any pronouns there given refer to the Honourable Leader of the Opposition. Sir, can I continue?
Continue, Honourable member, Christ.
Sir, the Honourable Leader of the Opposition pomposetted, carried on, lambasted the Honourable Attorney General on the basis that we have in this legislation pulled away a constitutional right, a common law right, the right to corroboration. Sir, obviously, the Honourable Leader of the Opposition has not availed himself of the opportunity to read Section 28 of the same Sexual Offences Act that we are now amending. So the existing and current section reads, subject to Section 31, where an accused is charged with an offense under this act, no corroboration is required for a conviction. It goes on to say, but the judge shall warn the jury that it may be unsafe to find the accused guilty in the absence of corroboration. It does not require corroboration, sir, but that's not the first place it came. It is not that that happened to drop in to that piece of legislation, sir. In Section 136 of the Evidence Act, 1994, as far back as 1994, corroboration was abolished. There is no requirement under the laws of Barbados as of today's date for corroboration in sexual offences trials. None. So I simply wish to point out that the Honourable Leader of the Opposition, perhaps, sir, due to, I don't even want to use the word ignorance in its purest term, ignorance being a lack of knowledge, but the Honourable Leader of the Opposition clearly is not even aware of the substantive act that we are coming here to amend. We have taken away no right. The Honourable Attorney General made the point that corroboration, the requirement for corroboration does not exist in our laws at all, under anything. It is not required for sexual offences, for murder, for nothing. It is not required at all. It not being required, and not being required in most common law jurisdictions, it is a nonsense for a judge to turn around and warn a jury, you know what, this is not required, but it may not be safe to do it without it. We've taken nothing away from the defense of the accused person. His lawyer is perfectly in order, is perfectly entitled to when he is summing up, to when he's giving his closing, even during the cross-examination, to drop it, put it, address the jury and advise, you know what, there ain't no requirement for corroboration, but this is unsafe. This evidence does not reach a point that it is safe to convict this person. In this case, in these circumstances, quite frankly, it would have been best if somebody else could say something. It would have been best if we had DNA evidence to throw in it. It would have been best if something. It is not required now. What we have removed is the obligation by a judge to give a warning about the safety to convict in the absence of something that is actually not required. It is a legal nonsense, effectively. All we have done is to clean that one up. I am sorry if the Honourable Leader of the Opposition had a trial looming in which he planned to use the fact that there was no corroboration as the defense for his client. Well, I am just, sir, as a helpful, I mean, he is in the constituency next to me, as a helpful neighbor, and yes, he did invite my constituents to his camp, so I'm returning the favor and advising him that that limb on which he sought to rely doesn't actually even exist now. It didn't since 1993 or 1994. So I hope I have cleared that up entirely. Let me now, sir, go to the other thing that he harped on and hanged on. The Honourable Leader of the Opposition questioned the fact of the amendment, I believe it is to Section 3 of the Sexual Offences Act. He questioned the government's use of the word spouse. He questioned whether or not there was something sinister in the use of the word spouse as opposed to husband or wife. He even, sir, went so far, and the word spouse itself is gender neutral. It is. He even went so far as to say where we all know in the Interpretation Act that spouse can refer to the masculine or the feminine. He said he would have been more comfortable if the legislation had instead said where a male spouse commits an offense against a female spouse, or a female spouse commits an offense against a male spouse. I happened, sir, to glance at the gallery where the consultants on legal drafting The ones we rely on to draft our legislations were over there, and I don't want to misinterpret the expression of the judge because he is wearing a mask. But I saw his eyes, and I'm sure there was a tear. But I definitely saw him cringe. Sir, I will speak slowly to allow the honourable member to be in a position to avail himself of some education, sir. The existing Sexual Offences Act, the existing one that we're amending, sir, in the interpretation section, which is section 2, actually the only thing in there that's interpreted, the only definition in that particular act in the interpretation section says, spouse means a lawful husband or wife, as the case may be. It means a lawful husband or wife, as the case may be. The problem, sir, comes in that when you actually got into the meat of the legislation, into the actual section, that is section 3, sir, it spoke about section 3.5. A husband who commits the offense of rape is liable on conviction or indictment to imprisonment for life. It defines spouse, but used husband. That created, sir, a confusion. When we were looking to draft the amendment to the legislation, and I can speak because I was involved in the drafting of it. When we were looking to draft the legislation, the definition of rape, as the honourable member pointed out over and over, the definition of rape no longer is the traditional rape. The traditional rape, sir, somebody thinks of a man introducing his penis into the vagina of somebody else. That was the definition of rape. That was rape all the time. So it didn't contemplate, sir, buggery. Buggery is an offense all of its own. It didn't contemplate buggery. It didn't contemplate anything else. The question was mooted for many years. What if the female in the relationship is the aggressor? What if the female perpetrates an act of violation against the male? It doesn't meet the standard of rape because a woman could not rape a man. We clarified that years ago by saying rape can't just be a penis. If you insert anything into an orifice and they extended the orifices, it wasn't just vagina. Because if a male raped a female by vaginal penetration and somebody else raped a female by anal penetration, it wasn't rape. Rape required the introduction into the vagina. I'm sorry to be so granular, sir, but it is necessary. The definition of rape was extended to include the violation of the vagina, the violation of the anus, the violation even of the mouth. If somebody sticks their male part into your mouth, it is rape. It is not forced oral intercourse. It is rape. You ain't getting permission to put it there. So, sir, we could not have spouse being defined as a husband or wife and then having the offense of rape in the legislation only referring to where a husband does something and not where the wife does it. So if even we go to the anomalous, the situation where we're even clarifying husband to wife, we're saying that no, everything a husband can be charged for, the wife can be charged for as well. However, when we look at the legislation, we actually saw something else. That while spouse refers to a husband or wife as the case may be, it does not take into account the definition of spouse in Barbados generally, which also includes unions other than marriage, spousal relationships. So someone in a union other than a marriage, where as far as Barbados is concerned, you are effectively married. You're not married in the church, you're not married in the court, but you, the woman, have all of the rights under the Succession Act and all other pieces of legislation as a married person. But under this legislation as it stood, the provisions in relation to rape didn't apply. All we did was clean that one up. It was determined that it was a nonsense to make provision for a husband to rape his wife or a wife to rape the husband and not make the same provision in a spousal relationship, which we otherwise accept as having the force of law in Barbados. So it is not, I sat down, sir, and listened to the Honourable Leader. I almost said him. I sat down and listened to the Honourable Leader of the opposition, sir, start to ride his horse off track. Then he started to gallop. And normally I would have stood up and tried to clarify. But I thought, when I do that, he takes offense. When I do that, instead of looking at the goodness of my heart to steering you on the right, the Honourable Leader of the Opposition invariably takes offense and comes after me. I thought, you know what? Let him go along. Let him go along and say whatever he wants to say. Let him go along and put all his years of legal training into his address. Let him go along and put all of his research that he did into this piece of legislation on the table. And at the end of it, I will abandon everything else I have to say and come and deal with that, because I would then get the opportunity to speak unmolested, or so I thought. But to clear up for the avoidance of everybody, and I can actually, as I said, sir, sometimes you try to look into the minds of what the drafters were thinking. I can't speak for the future, but I can tell you that at the point of drafting that piece, there was no contemplation being given to any same-sex marriage, any change of legislation, any whatever. But I'll tell you, sir, one thing that did give me some cause of concern. And we as the government govern for everybody. We can't pick and choose who we want to govern for. What gave me some measure of concern, sir, was the venom being spewed by the Honourable Leader of the Opposition, that he hopes that this offense and protection applied to heterosexual couples and was not intended to apply to homosexual relationships. First of all, with the definition of rape, any person, also gender neutral, who does X, Y, or Z to another person, also gender neutral, without their consent, is guilty of rape. So they're already protected. Whoever he's seeking to exclude by this is already protected. But that was not even what bothered me. What bothered me was that you, the Honourable Leader of the Opposition, who hopes one day to lead this country, is starting by saying that he is picking and choosing who in this country should receive the protection of the law. Because if it is relating to a homosexual relationship, we want it out. That is what gave me the most pause. I don't have to agree with the way somebody lives their life. I don't have to agree with the choices they make. Quite frankly, sir, I don't agree with most things that the Honourable Leader of the Opposition does or says. But let anybody come and tell me that he should be excluded, and I'm saying he, the general he, should be excluded from the protection of the law because I don't like what he represents. I don't like who he is. I don't like what he stands for. I don't like how he dresses. I don't like how he behaves. Then I would attack that person on the behalf of the Honourable Leader of the Opposition or whoever else somebody is seeking to deny the protection of the law to. That is the part that gave me the greatest pause and caused me concern. But I hope, sir, that having spoken thus far on that perhaps everybody is now on the same page. There's no subterfuge in here. When the government was forced to amend the legislation because of the ruling of Justice Michelle Weeks in a case, and that case, sir, quite frankly, it centered around what was serious indecency, what was gross indecency for the purpose of homosexual relationships. That's what it centered around. So it wasn't that we did it. The judge made a ruling. She made a ruling that serious indecency was too vague. That it is almost impossible to clearly define it. Serious indecency at that point in time, sir, was defined, 1 second. I think it was section 12, right?
Section 12.
An act of serious indecency is an act, whether natural or unnatural, by a person involving the use of the genital organs for the purpose of arousing or gratifying sexual desire. Well, sir, if anything begged for an explanation, it was that. And she rightly said it was too vague. You can't properly enforce this. You can't properly make a judgment on it. It was too vague. If it was too vague to use with 2 adults, it was too vague also to apply in the section with children. So she struck out the entire section. As the Honourable Leader of the Opposition said, it created a situation for us. Because that was the heaviest penalty you could get in relation to non-penetrative offenses against a child. Non-penetrative offenses against a child. That is the section for the rest of Barbados who needs to understand what are related to. If somebody troubled a child, or forced a child to trouble them, but it didn't amount to penetration, that was what you charged the person under. If you made a child perform oral sex on you, if you made a child masturbate you, if you masturbated the child but didn't cause any penetration, that was the section that you were charged under. The court said it was too vague. So we were left with a situation where you could still have sustained a charge against somebody who did those acts under sexual abuse, sexual assault. But it carried a lesser penalty than those. So we, recognizing that the judge has struck down these sections, and we said, you know what, quite frankly, we can't actually argue with that. We had to put something else in its place. It did not make sense to just go and address children. It did not make sense to just go and address Section 12 when a lot of other things in the legislation needed addressing at the same time. So we took the opportunity to plug all the, bad turn of phrase, but I'm already there. We took the opportunity to plug all the holes. We took the opportunity, sir, to correct all of the missteps, all of the things that were missing or didn't make sense in the legislation. For example, singling out a husband for rape when it should be a wife as well, and not acknowledging the fact that spouse was actually used to cover the definition of husband or wife. There are certain acts sort of have crept in to our culture. There's a grooming. We recognize sort of across the world, children are groomed. A perpetrator, a pervert, would single out a child and say, you know what? Let me get there gently. I don't want to frighten the child. Let me build a trust. Let me get the child a sweetie. Let me befriend the child who is crying and put myself in a position that the child can rely on me. Let me get that child to trust me. And then let me start with gradual things. We accept that is there. We didn't have provision for it. In order to protect our children, we can't wait until the child has been abused. We had to look down. We had to look forward. What are all the steps now that we know lead to the abuse of children? Let us cut it at step 1. Obviously, sir, you can't, if somebody gives a child a sweetie or helps what a child wants, you can't read anything of that. But if that person seeks to do it a second time and is showing their propensity to establish a pattern, then we have to step in to protect our children with the grooming. Grooming was never there. That's a major step. That's a big one. That's a big one for us. I congratulate the Attorney General for bringing that one in. But sir, we then look at pornography. We look at the reality of our situation. People trade in pictures of children, right? Adults are free with their cell phones, sir, to send a picture to whoever they want of whatever they want, if it's themselves. I can trade pictures, sir, with anybody. I wish, if I choose to do that's my business once the person's adult. But we then look at protecting children from, I guess, non-invasive abuse. If you circulate pictures of children, then we accept on the Computer Misuse Act, on all them things, that you're doing wrong. And the defense always used to be publishing, if you're published. I didn't publish. If you circulate and send it to somebody else, that's where the offense was triggered. But we say it has to be more than that. You actually can't say, well, I have these pictures of a child on my phone or on my computer. I ain't circulate them. So you can't really penalize me. No, you shouldn't have them at all. So we've taken the bold step, not just that you're circulated, not just that you're offering for sale, not just that you're transmitting. If you even have them, because there is no excuse. If even you are not sharing them with somebody else, you are actually using that child and those pictures for your own gratification, and that should be an offense. And we took the bold step to make that one an offense. The school is not yet finished. School is still in. We took the bold decision to go all out to protect our children. This is as cutting edge, sir, as it gets. This is as new as it gets. This is taking into consideration every single thing that we can. In relation, sir, coming off of the children, and I had indicated that when I was going to move away from addressing the Honourable the opposition, I would let the chairman know, so I'm off of him. No, sir. I can't speak to the presence or absence of anybody in the chamber. Sir, with the hearing in camera, the court should only hear the evidence of the complainant in camera. The court is only obliged to hear the evidence of the complainant in camera, but the court also has a discretion, sir, if something is prejudicial or the prejudicial value outweighs the probative value to actually make certain decisions. But why is that necessary? It is very difficult for a child. A child is treated differently in a court of law. You have to create a safe environment. It is hard enough for a child to relive a nightmare. I had a goddaughter, sir, who was afraid of clowns for some reason. And, you know, we always think that the best way to get somebody over there first is expose them to it. So you buy a little comical plastic clown. And that child bawled and cried so much. But that was traumatic for a child. We didn't understand it. It seemed like a small thing for us. I had another goddaughter, sir, who was afraid of dogs. So I put a 6-day-old puppy with his eyes closed. I brought it to her to put it in her hand. And so if I didn't catch that puppy, she was traumatized by a 6-day-old puppy. So if a child can be thus traumatized by things, we have to understand that to relive an experience, it is hard enough to do it with a judge who's trying to speak to you in words that you might understand. It's hard enough to do it.
Continue, Honourable Member.
No clowns, puppies, or children were hurt in the stories I just related, sir. But, sir, you cannot put that child or further a complainant, if they're not in a position to do it, to have to give the evidence in front of an entire courtroom, in front of a courtroom with persons watching, because criminal trials are open to the public. You can't make them do it with the reporters in there, with everybody watching you. That person will probably damage their own case, not because they can't give the evidence, but because they're so frightened and so traumatized by having to do it again. So you have fairness, sir, in a trial is not only fairness to the accused person, it also has to do with fairness to the victim or the complainant, right? And we have to create the environment for that. So I approve and appreciate, sir, the hearings in camera for taking the evidence of complainant, sir. The other thing, sir, the sexual communication with a minor, right? and causing a minor to watch sexual activities. Our focus before we did this was on the act, the sexual act itself, or some manifestation of a sexual act. We have expanded the reach and protection of this to be anything that is not appropriate for a child to see, feel, or experience. So you have no right to be showing a child pornography. There's no justification for it. You have no right to make a child watch you perform a sexual act. Or you have no right to masturbate in front of a child. All of these protections are now clearly into this legislation. We have gone as far as we didn't just address the lacuna by striking down section 12. We went far to make this contemporary. Everything we can contemplate that might put a child in a position that it should not be in as a child, so we have looked to deal with and address in this legislation. Sir, we also have dealt with persons who may have the IQ of a child, persons with a mental disorder or physical disability. The existing legislation, I don't want to look for it now, but I think the existing legislation mirrors what was in the Immigration Act, and it talked about idiots, imbeciles, feeble-minded persons, etc. That has no place in any piece of legislation in Barbados, right? We recognize mental health concerns, we realize mental health issues, we realize retarded development of persons. We recognize all those things, and the law must actually reflect those realities as well, sir. So, if you know somebody is suffering from a mental disorder, although the person may be over 18 or over the age of majority, if you know that person cannot really understand what they're doing, be in a position to consent to it, then you're committing an offense as well. So we're protecting, sir, not just children, but we're also protecting those who may be at the age of majority, right? But you know that they don't have the developmental capacity to actually understand what they're doing. We also, sir, the age of criminal responsibility for most, I think it's 12 years old. The age for children under this act was the age of consent is 16 years old. We had a number of different ages contending for what actually constituted a minor under this legislation. So we have clarified that one up entirely. The other thing that is retained, and we have to make allowances for certain things, sir. Usually before it was between 14 and 16 without their consent. You acknowledge that there was a space in there, sir, that there was an argument. I'm treading carefully because the legal position, sir, may not be the appropriate political position, but I'm treading carefully on it. The acknowledgement was that if a child was between 14 and 16 and was consenting, and you actually believed that they were over 16, then it couldn't be a sexual offense. There was some leeway in there.
Young man's defense, Honourable.
Correct, yes, sir. Right now, they've stripped that away. We've taken out the 14 in there. The reference of 14 is 16. 16 is the age of consent. Anybody under the age of consent can give consent. So it doesn't matter whether they were willing. We're not going to lessen the offense because they were willing. The law now says lucidly clearly that 16 is the cutoff age. If you are above 16, 16 and a day, or is a 16th birthday, you could do whatever you want. If you're below 16, you cannot consent. But they have retained in there the young man's defense. And the reason, because we had great debate over the retention of the young man's defense. It was not in the original drafted legislation, sir, but it was put back in. For those who are wondering what the young man's defense is, it says if the person is between 14 and 16, and you reasonably believed that they're above 16, so there's some people who look mature for the age. There's some persons who may actually try to fool you and present you with a false ID. There's somebody who may tell you, I am 18. If you have reasonable cause to believe, I understand, sir, it is reasonable cause to believe, because if you go and pick up a school child in junior school uniform, and the child telling you they're 17 years old, you gotta ask yourself some questions while you're there, right? If you have reasonable cause to believe that the child was between 14, the child was over 16, and they were between 14 and 16, and you were under the age of 24. I don't know what case made it the age of 24, but you, the person, have to be under the age of 24, technically still a young person. Then you may have a defense to rape, to statutory rape, to rape. But there's a caveat. You can only use that defense once. If you have cause to use that defense a second time, the court is of the opinion where you didn't learn. You took somebody borderline the first time, you got off from it, and you went back again, then you're not serious. So, sir, all the protections that existed before, I know that we are well into lunch. All the protections, sir, that existed before are still in. The anomalies, sir, the gray areas have been clarified. The area in relation to spouse and husband vis-a-vis rape, and where the rape is applicable, that has been clarified. The fact that it applies now to spousal relationships has been clarified. There was no need to put male spouse against female spouse and female spouse against male spouse. Sir, that is a legislative nonsense. That has been clarified in here on the floor of Parliament to those who expressed the concern. The issue in relation to corroboration, I believe, sir, has been clarified. To all who have ears and wish to hear, they now know. So I wish, sir, to thank the Honourable Attorney General and those who were instrumental, sir, in drafting the legislation and taking the opportunity to draft the legislation and correct not just the issue of striking down of Section 12, but all the other things that appear to us to be in need of addressing at the same time. I just want to leave with this one thing, sir. While people talk about Section 12 and that we left children unprotected, it was not that children were unprotected, because any offense against a child could still be brought under one of the other sections of the legislation, sexual assault, but the penalty would have been less. So we accepted that the penalty, it created a situation where the higher penalty was for the gross indecency and serious indecency. And we needed to put a provision in there that kept it as serious or made it even more serious than it was at the time when the section was struck down. So this does that. So the penalties range up to life in certain aspects. So the only issue that I can actually see, sir, is some lawyers saying, well, you did away with the warning, which is going to make our life even more difficult. But a skilled lawyer, sir, will be able to cover that some other way and address that in his wrap-up. So there's no prejudice to anybody, but persons are greater protected under this piece of legislation, under these amendments, than they were before. So I, sir, in light of all of that, have no difficulty at all and firmly recommend this legislation and support it entirely. Thank you, sir.
Honourable Leader of Government Business. The question is that this honourable chamber be suspended until 3 p.m. All those honourable members in favour, please say aye. Those against, please say no. Me think the ayes have it. This chamber stands suspended until 3 p.m.